saying I want to thank Judicial for inviting me here to speak today. And I want to thank you all for joining me today to talk about, as Rich says, a very important topic, the Eagle Owners Policy, as we call it, but more commonly known as the TIRSA Owners Extended Protection Policy, or TOEPP. I will be using TOEPP, so I don't have to say the TIRSA Owners Extended Protection Policy over and over again. As Rich said, this is a 1-hour credit. I will be speaking for 50 minutes. And I hope to, at the end of the presentation, to have some time for some questions. Please put the questions in the webinar chat if you have them throughout the presentation, and I will try and address them at the end, or Diana will send them to me after if I don't have time to get to them. So with that, let's go through our agenda. So our agenda today, we're going to go over first the basics of TOEPP, the costs and the benefits of it to both the consumer and the agent and you as their attorneys. Some real scenarios that we can see, some marketing materials that First American has prepared and that really highlight the differences between the standard owner's policy and the TOEPP. And then we're going to go into some of the specific covered risks, because certain ones have deduction limits and liability limits. So we're just going to go over those just so that you as the attorney are adequately prepared to present this to your clients, because those are the most important people here. And finally, what goes into the underwriting of the TOEPP policy? What might Judicial ask you to provide? What we might need in order to very accurately go through a TOEPP policy and make sure that your client has the protection they need. So with that, okay, so TOEPP, the basics. Section 20 of the manual, the TIRSA Owners Extended Protection Policy for Residential and Real Property. A TIRSA Owners Extended Protection Policy may be issued only if the property is improved by residential real property. And on the next couple slides, we're going to specifically go into what is covered under residential real property, because some people might not understand that. Does mixed use property get involved? If it's a apartment on top and a storefront on the bottom, can you get the TOEPP there? So if the insured is a natural person or a living trust established by a natural person for estate purposes, even if the trustee is not a natural person. What this means, title cannot be held in the name of a corporation, a LLC, a company, or a partnership, whether general or limited. It's strictly limited to a natural person or a living trust established by a natural person for estate purposes. Okay, so let's get into what is considered residential real property. Residential real property is defined by 3 characteristics for the most part. It's real property improved by a 1 to 4 family dwelling, an individual condominium unit used as a dwelling, or an individual cooperative apartment or unit used as a dwelling. So residential real property does not include land which is improved at the time of the issuance of the policy. So vacant land, out of the question, automatically not residential real property. Even if a house is going to be put on the property, if you're buying it and getting a policy at the time that it is vacant, you cannot get the TOEPP policy at that point. Real property improved by a 1 to 4 family dwelling used in part, but not entirely, as a professional office shall be deemed to be the residential real property. So for example, you have a house, your client has a house, they're a psychologist, they're a doctor, and they run part of their business out of their home, you can get the TOEPP there as of right now. If you just live there partly and the whole building is used as the office, which is unlikely, I know, but we like to just throw that out there, you can't get it. Property with any other kind of mixed use shall not be deemed residential real property. So again, it needs to be a professional office. What that means, storefronts are not professional offices. So again, in the doctor's offices, the attorney's offices, the psychologist's offices, those are what we're talking about when we're talking about professional offices. So let's get into a few examples of residential real property. Example number 1, parcel A is unimproved, land being purchased to construct a 1-family dwelling. Again, we went over this in the last slide. Parcel A is not residential property here. Doesn't matter that they have, we have all the builders lined up, we have all the contracts lined up to put a house on it, so we'd like to get TOEPP. It doesn't matter. At the time of the policy, if it is a vacant land and nothing, and a 1 to 4 family dwelling has not been placed upon the vacant land as of yet, then it is not eligible for the TOEPP policy. Example number 2, Parcel B is a 2-family home. Part of the house is used as a professional office, such as a doctor's office. Again, talked about that in the last slide. The other part of the house is used as a residence. Here, Parcel B is a residential real property. Example number 3, Parcel C is a storefront with 2 residential apartments above. Parcel C is not a residential real property. Property used as other than a residence or as a residence with a professional office is not residential real property. So just quickly, let's go through those 3 again. Vacant land, not residential real property, not eligible for TOEPP. 1 to 4, 2-family home with a doctor's office and part of it, eligible for the TOEPP, is considered residential real property. 2 residential apartments with a storefront in the bottom, not considered residential real property, therefore not eligible for TOEPP. So let's talk about the cost of the TOEPP, because your clients are going to ask you, well, what do I need to do? What's the difference for me? Why should I get this? How much extra does it cost? So the premium for the TOEPP policy shall be 120% of the owner's rate. This is from the rate manual. So if you have an owner policy for $1.5 million, a regular fee policy premium here would be $6,338. The TOEPP premium would be $7,605. So that's 20% of 120% of the owner's rate. So the additional premium here is $1,267. So you might be thinking, well, what's the difference between this and the regular policy? Why should my client be spending an extra $1,200? The benefits to the consumer are, I don't want to say nuanced, but they're very important to explain. While the benefit of increased revenue to an agent and an underwriter is clear, the challenge here is explaining to the consumer, which is your client, why they should be paying 20% more for a product, which over the years has not been the norm. And to do this, we must give you, as the attorneys who represent the insureds, the tools and the information to show them why your clients will be better off with the TOEPP policy. Our job is to show you all that why it is in your best interest, and more importantly, your client's best interest, to deviate from the long-established custom and practice of having your clients purchase the standard Alta 2006 owner policy. So, in a standard owner policy, covered risks. Number 1, someone else owns an interest in your title. Number 2, someone else has rights affecting your title arising out of leases, contracts, or options. Number 3, somebody else claims to have rights affecting your title arising out of a forgery or impersonation. Number 4, someone else has an easement on the land. Number 5, someone else has a right to limit your use of the land. Or number 6, your title is defective. So that's what we see in a normal standard policy, and you see those same covered risks in the TOEPP policy. So how do these risks differ from the standard policy to the TOEPP policy? It's the next covered risk which makes the policy such a game changer. Any of the covered risks 1 through 6 occurring after the policy date. You know, it's our job to explain to our clients, title insurance isn't like home and casualty insurance. It's not like car insurance. Those are insurances you're usually getting for things that happen after you buy your policy. Title insurance, for the most part, is there to cover you for things that happen before, defects, something that's been missed by an underwriter, mortgages, judgments, something that could hurt your client going forward in the future. Well, the TOEPP policy gives you that, plus it gives you things, it gives you coverage for things that occur after the policy date, which Rich is bringing up a great point in the beginning. He's talking about what's going on in Suffolk. You know, forgeries, hacking, with everything going on in Suffolk, We are on high alert with forgeries, intervening liens, mortgages, judgments being placed on the record that we can't search at the moment. If you have TOEPP, that protects you even after you buy your policy. It doesn't only cover the things that are behind the date of that you get it. It covers the dates after. So we as title professionals understand the concept that with the regular 2006 policy, post-policy events are not covered under this policy. However, you certainly should not expect your average consumer buying a residential piece of property to understand the concept of post-policy events and the fact that they are not covered. And it has been our experience that some practicing attorneys even struggle with this concept, and it is not always clear what coverage their clients are actually getting when they're paying for an owner's policy. Excuse me. So let's go through some examples. Mr. and Mrs. Smith purchased a single-family home on April 30th, 2021 in New York City for $1.5 million and move in on May 1st, 2021. Transactions an all-cash deal. On July 30th, 2021, Mr. Snake, a party working at the real estate broker's office, goes on to ACRIS, New York City's free online property records system, and finds the Smith deed. And seeing that there is no mortgage, decides that this will be an easy property to target, and forges a deed conveying title from the Smiths to an LLC, which Mr. Snake has formed. The documents are all properly notarized, as Mr. Snake was able to search ACRIS and find the name of a notary and the notary's license number, which Mr. Snake then used to create his own notary stamp, which is not very difficult to do, as you can buy all of this yourself and the materials at any office supply store. Mr. Snake lists the transfer as a transfer between relatives on the transfer documents, and 30 days later goes to Bank A and applies for a $250,000 line of credit. Loan with little investigation, since the LTV ratio is so low, Mr. Snake executes the mortgage that gets rewarded. Mr. Snake draws on this full amount of credit line and moves out of the country, having pulled the stamp on a dozen of properties, and settles nicely with the money he has sold. After Bank A fails to receive their payments for a few months, they begin their foreclosure proceedings and serve the foreclosure documents at the home where the Smiths have settled in. The Smiths immediately called their attorney and directed the attorney to file a claim on title policy. If the Smiths here purchased standard Alta 2006 policy, they'll be very upset to learn that this is a post-policy event and they are not covered. If the Smiths here had purchased the TOEPP policy, well, they wouldn't cover for the policy event. So, question for you all to ponder, and we can talk about definitely going forward at the end, or you send me questions on it. Do we as attorneys, when representing purchasers, have an obligation to inform their clients of the availability of TOEPP and to explain additional coverages and benefits at same? Is it malpractice if we neglect to make their clients aware of this product? You know, my dad does a CLE on ethics, and this is one of those topics that attorneys struggle with. It's okay, on one hand, we have a product that's 20% more expensive to our client, and God willing, or just hopefully, they won't ever need to use it. They won't ever need to have to deal with someone putting mortgages on their property or deeds on their property or whatever it is. But in those cases where it does happen, and they find out that there is a product out there that could have better protected them, are they then going to blame us as their attorneys for not explaining to them that this was out there? Are they going to hold us accountable? Are they going to hold us responsible for now having to deal with legal fees, clearing up the matters, whatever it is? It's a question that's asked. It hasn't been tested yet. Nobody has obviously brought a grievance, that, as far as I know, to the ethics committee about it, but it's something we really need to consider and think about. What else is included? Post-policy forgeries, some post-policy encroachments. This includes fences, retaining walls, curbing, and driveways. This is a great one to talk about because I talk about this in my claims presentation as well. When you get a policy and you have a property A and property B, there's a fence along the line. You're good friends with your neighbor. It's never been an issue. Your neighbor goes and sells. You buy your policy, right? Nothing. It just says fence is on. Fence varies with the line, whatever it says. Your neighbor sells, and the new owner comes in and he stakes out the fence, and he goes in and or he puts up a fence. Let's say that's a better example. He goes up and puts up a fence now. You're not protected there. You're not protected under a standard policy unless obviously your policy specifically calls it out. But if it doesn't call out, that there's an issue and they go and put up a fence, that's something you have to deal with your neighbor. Under TOEPP, fences are covered if someone goes and puts up a fence after. Again, up to a certain point, which we will talk about later, but that's an added protection that the TOEPP policy gives you that the standard policy won't. Post-policy adverse possession, that falls under the fence line we were talking about. It falls under the fence issue we were just talking about, but it also has to do with retaining walls. It has to do with sheds that are on your property or sheds that are on your neighbor's property, any of those kind of potential issues. Post-policy easement by prescriptions, coverage if another claims a right to use a part of the insured's land as easement because of continuous use over time. What does this look like? Maybe you have a property that's on the beach, or your client has a property that's on the beach, and there's a pathway that for 10, 15, 20 years has always been used by pedestrians to get to the road, from the road to the beach, which is a public beach on the other side of your property. Nothing's raised in your title report about it. There's no easement. There's no recorded easement on it. And you go and try and put up a fence now blocking off that. And somebody sues your client saying, hey, you can't put up this fence. I've been using this walkway for years. Well, under standard policy, not covered. Under a TOEPP policy, potentially is covered. Post-policy damage from extraction of minerals or water. We would see this more upstate. Minerals or water doesn't just mean rocks. It could mean timber. That's considered under the minerals. So that's just another item to consider, especially if we're talking about upstate properties. All of these post-policy matters would not be covered under the standard 2006 Alta Owners Policy, but would be covered under TOEPP. Again, I want to highlight this in light of the frequency and ease of committing cybercrimes, frauds, forgeries. This coverage alone may be the best selling point when educating your clients. We've already talked about Suffolk, but wire fraud is one of the biggest issues that we are seeing growing in this country. It is becoming a more and more active topic in my claims CLE. You might be thinking, well, how does that really affect me? Payoffs, proceeds, whatever it is, payoffs, proceeds are probably the biggest examples when it comes to your individual clients. If those go missing, mortgages might not get recorded, mortgages might not get satisfied. These are items that really need to be considered when you're talking with your clients about what kind of coverage they're expecting. What we don't want is 10 years down the road, a client coming back to you saying, hey, you had me buy this policy, but they're telling me I'm not covered for anything. We want to make sure that they know exactly what they're getting. So because of that, First American has put together some great marketing materials that we're going to go through, and they really highlight the difference between the standard owner's policy and the TOEPP policy. And I don't want to say they'll make your lives easier, but they definitely give you your talking points, and they help you present it in a more readable fashion for your clients. So here is the marketing material. It is the Eagles Owners Policy. As we go through the slides, it's a little more highlighted, so we can get through that. Okay, sorry. All right, so the first section, the First American Title Insurance Company's Eagles Owners Policy provides expanded title coverage for owners of 1 to 4 family residences, including condominiums, And coverages included in the Eagle owner's policy offer the highest levels of protection against homeowners. So a lot of this is repeating a little bit, but that's how important it is for me to get this out to you. Eagle's owner's policy benefits you won't get with the standard Alta owner's policy: post-policy forgery, post-policy encroachment, post-policy adverse possession, coverage extended to homeowner when someone claims to have the insured's title arising out of someone else's continued use and occupancy, post-policy easement by prescription, coverage if another claims right to use part of the insured's land as an easement because of continuous use over time, building permit and zoning violations, coverage for losses up to $25,000. Again, we're going to go into that a little more as we go forward. After a small deductible for building permit violations and forced remediation of zoning violations, and up to the full policy amount for forced removal of structures due to zoning violations. Expanded access, which includes expanded to include both vehicular and pedestrian access to and from the land based upon legal right. This one, people are always shocked to learn. This one's actually, it gives you the vehicular and pedestrian. You know, when you have a regular policy, it just says right to access. It doesn't go any really further than that. This sets out exactly what you get from it. Endorsements of improvements onto easements and setbacks, subdivision violations. Again, I know there's another, it's limited there, but we can talk about that as we go forward. Restrictive covenant violations, which is coverage provided for violations of restrictive covenants incurring before homeowner acquired land if the homeowner is forced to correct or remove the violation, or if the homeowner's title is lost or taken because of the violation. Structural damage from mineral abstraction or easement use, and encroachment of boundary walls and fences. Again, small deductible here. We'll talk about that as we go forward. This right here is my favorite chart, which shows the differences. It's nice and easy. It's okay, well, how do I present this to my client in a one-page summary that is very easy for them to understand? On the left-hand side, we have the Eagle policy in green. On the right-hand side, we have the Alta standard in red. It's pretty self-explanatory, but I will go through it. Obviously, someone owns or interest in title. A document is not properly signed, forgery, fraud, defective recording of any document, restrictive covenants. There is a lien on your title because of A, B, or C, which is a deed of trust, a judgment, a change of a charge by the homeowner association, or title is unmarketable. These are all items that are covered by both. 8 through 10 are items that are only covered by the Eagle policy or the TOEPP policy. Mechanics liens that come on. Forced removal of a structure because it A, extends onto another property and or an easement. Violations or restriction in Schedule B. Violations of an existing zoning law. And you cannot use the land for a single family residence because the use violates a restriction in Schedule B or zoning ordinance. These 4, or if you want to say 5 to 7 based on A, B, and C, are items that are normally considered post-policy events in the Alta standard policy and would not be covered. In the Eagle policy, they are covered. Sorry, I'm just making sure. Okay, so 11 through 24 is some more items that are in the Alta or in the TOEPP policy, but not the Eagle, but not the Alta standard. Excuse me. Unrecorded liens by homeowners association, unrecorded easements, building permit violations, restrictive covenant violations, post-policy forgeries, post-policy encroachments, post-policy damage from extraction of minerals or water, lack of vehicular or pedestrian access, map is not consistent with the legal description, post-policy adverse possession, post-policy prescription easements, covenants violation resulting in your title reverting to a previous owner, violations of a building setback regulation, or discriminatory covenants. Again, as you can see with most of these are things that might get noticed after your client purchases their property. A lot of post-policy stuff here. An Alta standard policy will not cover your clients. I know I'm repeating myself with that, but if you're going to take one thing away from this meeting or the CLE is there are a lot of things that the TOEPP policy will cover post policy. A ALTA standard policy does not cover post policy items. Number 25, just a few more: paying rent for substitute land or facilities, rights under unrecorded leases, plain language statements of policy coverage and restrictions, subdivision law violations, coverage for boundary walls or fence encroachments, added ownership coverage leads to enhanced marketability, insurance coverage for a lifetime, post-policy inflation coverage with automatic increase in value of 150% over 5 years, and post-policy living trust coverage. Okay, so let's talk about a revision that was made in 2018 by the rate manual. The TIRSA Owner's Extended Protection Policy has been revised effective April 8, 2018. The revision to the policy is a revision to Covered Risk 21. Covered Risk 21 of the TOEPP policy currently reads, your existing structures or replacement or modification made to them after the policy date or any part of them other than boundary wall or fences are damaged because of the future exercise of a right to use the surface of the land for the extraction of development of mineral, water, or any other substance, even if those rights are reserved from the description of the land or accepted in Schedule B. So the underlying text here has been replaced, and the covered risk under the revised rate manual reads, your existing structures or a replacement or modification made to that after the policy or any part of them under the boundary walls of fences are damaged because of the future exercise of a right to use the surface of the land for the extraction or development of minerals, waters, or any other substances, and this is the important part, unless those rights are accepted or reserved from the description of the land or accepted in Schedule B. The red underlined text is the new text. I just like to point that out for everyone, just because sometimes they'll see an old version of it, and I just want to make sure that the clients understand. So before I go on to this, the code for today's CLE is going to be 1125. Again, the code for today is going to be 1125. I'll just give everybody a couple seconds to write that down. One more time, the code is 1125, and I believe Dinah has put it in the chat as well for everybody. Okay, so how are we doing on time? We're 30. Okay, so we have about 20 minutes left. Good. Deductibles and maximum coverage under cover risks 14, 15, 16, and 18. So, limitations on liability. Okay. Covered risk 14, your deductible amount here is $2,000. Our maximum dollar limit of liability on this risk is $10,000. Covered risk 15, which is the building permit, is $4,000 deductible. Maximum is $25,000. Covered risk 16 is $4,000. Maximum $25,000. And covered risk 18, which is encroachment, walls of boundary walls of fences, $1,500. Max $5,000. We'll go into each one of these a little more. It's just important for these four to note that there is a deductible amount and there is a maximum dollar limit of liability when explaining it to your clients. Okay, limitation of liability. If we remove the cause of this claim with reasonable diligence after receiving notice of it, our obligations for the claim end, including any obligations for loss you had while we were removing the claim, the loss of the claim. Regardless of 6B1 above, if you cannot use the land, though, because of a claim covered in this policy, you may rent a reasonably equivalent substitute residence, and we will repay you for the actual rent you pay until the earlier of 1, the clause of the claim is removed, or we pay you the amount required by this policy if your claim is covered under risks 14, 15, 16, and 18. That payment is the amount of your insurance then in force for the particular covered risk. The reason 14, 15, 16, and 18 are pointed out here, again, I'll go back for you very quickly. These are the four that we'll usually see that might require somebody to have to move out of their home. Subdivision violation, a building permit violation that they can no longer build what they want to build, a zoning violation that is messing with the 1 to 4 family designation and requires them to leave their home while they fight it. That's why we see those limitations on liability specifically on those 4, because these are the 4 that sometimes have to be dealt with in different ways. Okay, so let's go specifically into each one. Number 14, because a violation of a subdivision law or regulation existing at policy date affecting the land. This can include you're unable to obtain a building permit after your closing. You're forced to correct or move a violation. So you buy something with a pool and then you find out the pool isn't up to code and you have to either remove the pool or you have to put money in trying to put a fence around the pool. That's an example that usually comes to my mind when it comes to this. Someone else has a legal right to and does refuse to perform a contract to purchase the land, lease, or make a mortgage loan on it. Number 15, the cost of the forced removal of your structures or any part of them other than boundary walls or fences, because that's covered in 18. As existing at policy date, because any portion was built without obtaining a building permit from the proper government office. You buy a property, you find out the bathroom on the 2nd floor is not up to code, or in fact, there was no permit pulled to add that bathroom at all. Number 16, the cost of the forced removals of your structures or any part of the structures other than boundary wall or fences existing at policy date, because they violate an existing zoning law or zoning regulations. They violate a setback. They're too close to the road. There's a shed that's too close to a fence or too close to your neighbor's property. Your building is too close to your neighbor's property. If you're out in Westchester, Suffolk, Nassau, whatever it is, that is covered under 16. Number 18, you're forced to remove your structures or any part of them as existing at the policy date because they encroach on your neighbor's land. This is why fences and walls are specifically singled out 14, 15, and 16, because they have their own coverage in 18. If the encroaching structures are boundary walls or fences, the amount of your insurance for this covered risk is subject to your deductible amount, again, which was $1,500, and our maximum dollar limit of liability shown in Schedule A, which was $5,000 for for the 5,000. Okay, additional covered risks. Coverage against a lack of actual vehicular and pedestrian access to the land, the standard ALTA policy. Because I want to, 17 is its own. It's not considered in the 14, 15, 16, and 18. 17 doesn't have a deductible or a maximum liability. Those 4 I specifically point out just because they have a maximum liability amount and a deductible amount. So again, coverage against the lack of actual vehicular and pedestrian access to the land. The standard ALTA policy ensures only a right of legal access, not access in fact. Again, it does not ensure the access in fact, it just ensures that you have a legal right, a right of legal access. Vehicular access to a condominium unit is, of course, carved out of this coverage, and it should be accepted in Schedule B when a condo unit is being insured. Coverage against the inability of the insured to use the land as a single-family residence due to violation of any existing zoning law or regulation. This can fall under 16 or 15 and 14, I believe. Increased policy amount. The policy amount automatically increases by 10% each year for the first 5 years, up to 150% of the policy amount. This is that inflation we were talking about. We know house prices aren't stagnant, and this gives your client a little extra protection on that as well for their policy amount going up. The insured is not covered under the Eagle policy against loss incurred due to the failure of existing structures on the land to be constructed in accordance with applicable building codes, unless a notice of building code violation appears in the public records on the policy date. Okay, so let's go through some underwriting requirements when we're talking about the TOEPP policy. What do we need? What do we as the underwriter need? What does judicial need? What might they ask you for? So a current certified survey. Review to compare structures noted on certificates of occupancy and compliance. We're looking to make sure there's been no tear downs, no building loans that, put up a new shed, put up a second floor on the bathroom. We're comparing what's there with what is on the new survey. We're reviewing in order to establish access in fact. We're making sure there is access for your clients. If Schedule B sets forth easements or rights of way, the survey must either plot them or the underwriter must be able to verify with certainty where the easements and right of ways are located on the survey. This is required in order to confirm that there are no encroachments onto the easements or right of ways by your neighbors, by the municipality, by the town, whatever it is. If there are covenants and restrictions or references to notes on a filed map establishing a setback requirement, the survey must note the structure setbacks. Underwriters and title officers, like judicial, must review each such instrument in conjunction with the survey and obtain any necessary affidavits, proofs in order to verify compliance with the terms of the accepted covenants, conditions, and restrictions. Underwriting requirements for full municipal searches. This includes certificates of occupancy, housing and building, violations. Underwriters and title officers will need to review the survey in conjunction with the record and building permits and the COs issued for the improvements at the premises and accept in Schedule B any facts that vary from this coverage. So anything that we might notice that's different from what they lay out. Underwriters and title offices will need to review the survey in conjunction with these searches, and as well as the local subdivision requirements and the COs issued for the improvements at the premises and accept in Schedule B any facts varying from this coverage as well. Underwriters and title officers will need to obtain and review a zoning search if there is any question as to whether the property is built in compliance with the zoning. Excuse me. Accordingly, when the review of title, survey, zoning evidence, and searches for appropriate municipal departments for building code violations, certificates of occupancy, or building permits for improvements on the land being insured discloses any state of facts varying from the insured afforded by a covered risk, it is imperative that an exception for the matter in question be set forth in Schedule B. If reliable searches of the municipality's records or confirmation that an improvement predates certificate of occupancy requirements cannot be obtained, then underwriters and title officers will need to evaluate all known facts and circumstances here, bearing on the nature of the use and type of improvement at a property. The addition of a deck will, for example, require more careful scrutiny. In the case of a minor subdivision or in a locality requiring subdivision approval, an exception will be raised in the report section captioned Schedule B exceptions TOEPP as follows. The land to be conveyed being part of a tax lot, proof of compliance with local subdivision requirements is required in advance to closing, or the policy will accept the consequences of the failure to obtain subdivision approval. Okay, what about a certified survey with an inspection? This is not the preferred option here. Again, I want to emphasize a certified survey is not only best for us, but it is best for you and your clients. But under certain circumstances, it can be utilized. A covenant or a CNR may relate to the use and occupancy of the property, as well as the nature and location of the improvements permitted on the land. Accordingly, the survey inspector must be directed to identify the use of the property. Is there a medical office or a retail establishment at the property? Are there multiple mailboxes or entrances suggesting an unusual use or occupancy? Note that information from a survey inspection bearing on use and occupancy may impact other covered risks, such as those relating to zoning, or even render the Eagle policy unavailable for purchase. An Eagle policy can only be issued to ensure an existing owner-occupied 1 to 4 family residence. For example, the inspection of a property discloses that the property has in part a retail use, a storefront. Council may determine that an Eagle policy cannot be issued here. Okay, let us go into New York City specific exceptions. So this is just relating to properties that are in the 5 boroughs. In the city of New York, when the title examination indicates that the property is a landmark building or is located in a landmark district, landmarks and building department searches must be ordered. If the city of New York, there is a letter commonly known as the Draper letter that may be available from municipal search companies certifying that the certificate of occupancy was properly issued and the improvements conform to zoning in effect when the certificate of occupancy was issued. Being time-consuming, expensive, this certification does not need to be ordered unless there is a clear need. I want to say unless there is a clear need to do so, and then only it should be ordered at the direction of the client after ascertaining the probable charge for the search. If there is some concern as to whether use of the property as a single-family residence complies with zoning, a zoning search is to be ordered from the company providing municipal searches. That search will identify the zoning classification for the property, the permitted use of the property in that zoning classification, can then be investigated by council. Municipal codes may be obtainable locally or they can be accessed on the internet. No investigation is required for property situated in an existing approved subdivision when a CO has been issued to a 1 to 4 family residence, or a letter, the Draper letter is issued that their improvements were built before the COs were required. Supplemental affidavits might or can be utilized for the TOEPP to handle those kind of issues. And with that, I will go over some questions and try and provide the best answers I can. If I can't provide an answer right now, I promise I will shoot you an email. I'll get it from Diana. So, Diana, do you want me to just go through the questions on the stuff?
I kind of combined some so that we could be efficient, because a few of them ask similar questions. So we'll go for like 5 or 10 minutes, and then any questions that aren't answered, just shoot us an email. We'll get it answered. And also, we have a YouTube channel, and we have a few 3-minute videos on TOEPP that might be a good tool for, besides a chart, a good tool to send a client possibly. Just a quick recap on what the TOEPP policy covers. So check out our YouTube channel. Do trusts qualify for TOEPPs, and why are corporations and LLCs excluded?
So do protective trusts? I'd have to really look into a protective trust. I haven't looked at one in a long time. The standard rule when it comes to trusts is it needs to be a natural person's trust. And what I mean by that is really a revocable trust or an irrevocable trust are typically what we see in terms of the TOEPP policy. Why are corporations and LLCs prohibited from getting the TOEPP? I wish there was a clear answer for that. I think the best reason I can probably give is they like to have they want to know exactly who is getting it. It's rather than, they don't want companies gobbling up all these properties, corporations specifically, and getting the TOEPP policy, and they're kind of then covered for everything in a way.
Okay. What's the difference between the market, the 5-year increase in protection, and a market value rider?
So a market value rider, that goes with the market. That increases with the fair market value of the property. So if your property doesn't go up, your policy amount won't go up. With the TOEPP policy, there is a 10% per year built-in increase in your maximum liability regardless.
Right, and there's a cap on that, whereas the market value rider, it's fair market value. So, yeah. May a current owner purchase a TOEPP policy, and can you buy one after closing?
No, it needs to be purchased before closing. I want to say the best reason why is if you have a vacant lot. Otherwise, people would go buy a vacant lot, put their building on, and then go and buy a TOEPP policy.
Got it. In a case of adverse possession, what costs or damages would be covered under the TOEPP policy?
So adverse possession, what I don't like about adverse possession sometimes with this is it can be covered. It's really covered by a lot of different things. Specifically, when you see adverse possession, the most common thing that comes to mind is a fence or a wall that needs to be removed, a shed that needs to be placed. So those would kind of be the costs that you would normally see, either helping the removal of a shed completely, the removal of a fence, or the replacement of one of those structures.
Okay. Looking to hear how fences and easements are covered. Do they have to be claimed when the fences go up? And if it wasn't, would it be covered when it's discovered, when the property is sold?
So that's why when I was talking about fences, I tried to make the distinction about fences that are already there versus fences that are placed after. When fences are there, you're less likely to see it because when you get a survey in those situations, the fence is going to be, especially when you need a certified survey, you're going to know how far off the line your fence is usually. And if there is a particular issue, that's why we see it a lot more when fences are put up, because that's when someone is cutting off another person from a piece of property that they claim is theirs. And it's not only fences. I want to be clear. Shrubbery, as weird as that sounds, is some putting up arborvitaes, putting up hedges. That's cutting off somebody from a piece of property that they might consider their own, and could be. And if they're cutting you off with one of those items, that's something that you can use the TOEPP policy for.
Okay, we'll get to two more questions. If a residential property is bought under a natural person and then converted to a trust or LLC later, does that cancel out the TOEPP policy?
That is actually a very good question. Diana, can you do me a favor and get that person's email? Because
Yes.
I will look into that. I am not 100% sure about that. That is a very good question that I will get back to you on that one.
Got it. And are any of the legal fees covered under a TOEPP policy? If you have a claim and you have to pay an attorney to represent you?
Again, that is more of a claims decision. I think it would be based. I think it would be case by case, whether claims steps in or whether they just are going to let the attorney handle the issue at the time. I can't speak to that, as that would probably be more of a claims decision.
Got it. Okay, in an interest of ending on time, I'll leave it at that. If we didn't answer any questions, please send it to me. Like I said, again, visit our YouTube channel. We have some really good videos on there as well. And our website also has information. So any questions, please reach out anytime. Thank you for a great CLE. We look forward to seeing you again, and have a great week, everyone.